You know that feeling, right? A check bounces. Ooh, more than just annoying. It can turn into this real legal maze, especially figuring out, well, where do you even file a case?
Exactly. Geography becomes surprisingly critical.
So our deep dive today gets right into that. We're looking at a really important question answered definitively by India's Supreme Court.
And it all revolves around Section 138 of the Negotiable Instruments Act, the bounce check law.
Right. The mission. Figure out when that check bounces, where does the complaint go? Is it where you, hand it over the counter or somewhere else?
And this recent Supreme Court decision gives us a crystal clear answer. It's about where your bank account is, where it's maintained, not just where you happen to deposit the check.
Let's look at the actual case. Prakash Chimanlal Sheth.
Yes, he'd lent a pretty significant sum.
38.5 lakh rupees. That's not small change.
Not at all. And he got 4 checks back in September 2023 from Jagruti Keyur Rajpopat. She was acting as a guarantor, but also had her own liability.
Okay, so he gets the checks, deposits them in Mumbai.
Correct. Deposited in Mumbai.
But then they bounced. Insufficient funds. The classic reason.
The classic frustrating reason.
So Prakash naturally wants his money back. He files complaints, but he files them in Mangalore.
Right, Mangalore.
And here's the twist. Both the local magistrate and the High Court of Karnataka basically said, nope, wrong place. They threw it out.
Dismissed. Their reasoning was all about territorial jurisdiction.
They said Mangalore didn't have the power to hear the case because the checks were deposited physically in Mumbai.
That was their whole focus, the physical act of presentation in Mumbai.
Okay, let's unpack this, because it seems straightforward, but clearly it wasn't. Why was focusing on Mumbai the mistake? What were the lower courts missing?
They missed a really crucial distinction laid out in the law itself. It was a fundamental misreading or perhaps an assumption based on the deposit location.
An assumption that the Supreme Court had to correct.
Precisely. It shows how critical the exact wording of the statute is.
So Prakash's team obviously fought back.
Yeah.
What was their argument against this dismissal? How did they turn it around?
Their argument was simple but powerful. They said, yes, the checks went into a bank branch in Mumbai. Fine.
Okay.
But Prakash's actual bank account, the one the money was supposed to go into, that account was maintained elsewhere.
Okay. Where?
At the Kotak Mahindra Benderwal branch in Mangalore. Account number and everything confirmed.
So the receiving account's home base was Mangalore, even if the deposit slip was handed over in Mumbai.
Exactly. And the High Court seems to have just, overlooked that detail or assumed his account was also Mumbai-based.
Seems like a pretty big detail to overlook.
It turned out to be the deciding detail, and this is where Section 142, Subsection 2, Clause A of the NI Act comes in. It's very specific.
What does it say?
It states clearly that the offense, the dishonoring, should be tried only by a court within whose local jurisdiction. And here's the key phrase. The branch of the bank where the payee maintains the account is situated.
Not where it was presented, where the account is maintained.
Precisely. And this wasn't even a brand new idea. The Supreme Court had already clarified this principle back in 2016. There was precedent.
The Bridgestone India case.
That's the one. So the legal principle was already established.
So the absolute key is distinguishing maintaining the account versus just depositing the check. For Prakash, presenting in Mumbai didn't change the fact his financial home base for that transaction was Mangalore.
And interestingly, even the respondent's lawyer eventually conceded that Prakash's account was indeed maintained in Mangalore. It had apparently been transferred there.
So the fact wasn't really in dispute once they looked closely.
No, the facts pointed clearly to Mangalore once that distinction was made.
So what did the Supreme Court finally say? How did they rule?
Well, the Supreme Court saw the error straight away. They stated very clearly that the magistrate in Mangalore and the Karnataka High Court had got the law wrong.
By focusing only on Mumbai.
Yes, by focusing on the deposit location instead of the account maintenance location as required by Section 142(2)(a).
So because Prakash maintained his account in Mangalore, filing there was correct all along.
Entirely correct. The law was on his side based on where his account lived.
And the final outcome for Prakash?
The Supreme Court allowed his appeals. The lower court orders were set aside.
Meaning?
Meaning the magistrate court in Mangalore was directed to take up the complaints again and proceed with the case. And they added expeditiously. So, quickly.
Good. So he gets his day in court, in the right court.
Yes. Justices can proceed in Mangalore.
So pulling this all together, the big takeaway is crystal clear now, thanks to the Supreme Court.
Absolutely. Jurisdiction under Section 138 It follows the payee's bank account, where that account is officially maintained. Simple as that.
And not where you drop the check off.
Definitely not. In this case, Prakash's account in Mangalore was the anchor, legally speaking, despite the Mumbai deposit.
Okay, so what does this mean for you listening? Why is this specific detail so important?
Well, it shows how what seems like a tiny detailed deposit location versus account location can completely change how and where you deal with a bounced check legally.
Yeah, if you run a business, get paid by check often, or even just occasionally receive one, knowing this could save a lot of hassle. Maybe even legal fees going down the wrong path.
It really highlights how precise you need to be with legal interpretations, especially financial law.
Yeah.
The wording matters immensely.
It really does. It makes you think. In today's world, everything's digital, transactions are flying everywhere, but this case brings it back to something quite physical. In a way, the official residence of your bank account.
That's a great point. It raises a bigger question, doesn't it?
Yeah.
How much do we really need to understand the sort of legal geography of our finances? Where do our transactions technically live? And could that understanding change how we bank or even how we approach legal issues down the road? Something to think about.